As I stated before, while the district court found for the out-of-staters in both cases, the Commonwealth wasn't happy about it. So they appealed to the Massachusetts Supreme Judicial Court. Now comes the Commonwealth and requests that this court grant direct appellate review and consolidate the cases of Commonwealth v. Dean F. Donnell and Commonwealth v. Philip Marquis. These cases involve pending appeals of the allowance of the defendant's motion to dismiss by the same motion judge in the Lowell District Court, which invoked novel but erroneous applications of Second Amendment constitutional law. The motion judge erroneously ruled out-of-state residents may not be prosecuted for unlawful possession of a firearm in Massachusetts if they were legally entitled to possess those weapons in their home state. Now, the Commonwealth claims that Judge Coffey did invoke novel but erroneous applications of Second Amendment constitutional law. Now, that may be true, but he did follow the Constitution of the United States, which supersedes the opinion of judges, even if they call their decisions constitutional law. The same motion judge has already dismissed 7 cases in total under this erroneous theory. The judge's rationale deprives the Commonwealth of its right and obligation to enforce its laws equally for all those who are within its borders. In addition to the 2 cases the Commonwealth is asking to be consolidated, there are 5 others currently in the appeals court. The Commonwealth makes a grave error in this motion, though. The Commonwealth's right to enforce its law do not extend to laws that violate the Constitution of Massachusetts or of the United States. When Judge Coffey found that GL 269 Section 10A violates the Constitution of the United States, he also found that the Commonwealth had neither right nor duty to enforce that law. Both Commonwealth v. Dean F. Donnell Jr. and Commonwealth v. Philip Marquis involved defendants who were legally entitled to possess firearms in New Hampshire, but were not licensed to possess those firearms in Massachusetts. Both defendants were charged with illegally possessing firearms in Massachusetts. Neither defendant had attempted to acquire a non-resident license to carry firearms within the Commonwealth of Massachusetts prior to their respective offense at issue. That, however, is the point. The law that prohibited these 2 men from carrying firearms in Massachusetts in these 2 instances has been found unconstitutional and therefore void in these cases. Finally, states have always been free to regulate who is allowed to possess firearms within their territorial borders, what types of weapons were prohibited, and where arms could be carried, imposing different standards in each sovereign. See, there's a difference between being free to regulate and to get away with regulating. Since 1791, the states have been prohibited from infringing on the right to keep and bear arms without due process of law. This is where the burden of proof argument makes sense. If there is a question as to whether or not someone can bear arms, the burden of proof must be on the state. By placing financial and training requirements on the exercise of a constitutionally protected right, the state effectively places the burden on the people to prove they are not prohibited, violating due process. The motion judge concluded that applying Massachusetts firearm licensing laws to non-residents within its borders violates an out-of-state resident's constitutional rights to travel and equal protection. This was clearly erroneous. Neither defendant had sought a Massachusetts firearm license. Therefore, the defendants were treated exactly the same as Massachusetts residents would have been who had made no efforts to avail themselves of the licensing statute. The Commonwealth claims the right of the 2 defendants were not violated because they didn't seek Massachusetts permission to exercise a right protected by the Constitution of the United States. Now, not only does Massachusetts want non-residents to get their permission before possessing a firearm in the state, this is the process the state wants them to go through. To apply for a non-resident license to carry firearm or a resident alien permit, you must apply for a non-resident license to carry a firearm or a resident alien permit through the Firearms Records Bureau. You'll need a complete non-resident firearms license or resident alien permit application, the required application fee, a Massachusetts Basic Firearms Safety Course certificate. You may also need an in-person appearance, a visa or copy of immigration card. This is not all. For example, the applicant is required to appear in person at the Firearms Record Bureau for the first non-resident license to carry application. Renewals will be processed solely by mail, and you will still need to renew your LTC annually. However, subsequent in-person appearances may be required at the discretion of the FRB. If required, you will receive an appointment notice by mail or email with your scheduled date and time to appear at this office. Appointments will be scheduled in the order that completed applications are received. Not only are you required to apply in person for your initial application, but you may be required to appear at any of your renewals as well. Well, this may not be a great expense or inconvenience for someone in, say, southern New Hampshire. For someone like me in Nashville, Tennessee, it's a very big deal. And don't forget, you not only have to pay for a firearm safety course, but your instructor must be certified by the Colonel of the Massachusetts State Police. Then there's the annual fee of $100, all so you can exercise a right protected by the Constitution of the United States and of Massachusetts. Yet the Commonwealth of Massachusetts sees this as a permissible burden to the exercise of a constitutionally protected right. Tell me, do you believe the Commonwealth would think the same thing if every government employee had to go through a similar process to exercise their right to enforce their laws? Somehow I don't think so.